welcome and thank you for signing up to this evening's webinar on Israel-Gaza, the International Criminal Court's prosecutor's application for arrest warrants with Professor Noam Lubell and Dr. Maria Varaki. For those who are joining us for the first time, my name is Mia and I'm the Executive Director of Renee Kassan, a UK-based Jewish human rights organization that works to promote and protect universal rights, drawing on Jewish values and Jewish experience. The modern human rights framework was developed in response to the atrocities leading up and during the Holocaust, and was shaped by prominent Jewish human rights lawyers. From the Universal Declaration of Human Rights, co-drafted by our namesake, Monsieur René Cassin, to the European Convention on Human Rights, a new framework emerged to counter the destruction of fundamental rights during World War II. It was designed to ensure its signatories respected the law and the rights of individuals as fundamental to ensuring peace and justice. At René Cassin, we work to remake the case for human rights values and to invigorate the language of human rights, both within the Jewish community and within the broader public sphere, so to strengthen the Jewish perspective's contribution to the furtherance of human rights. We do this through a combination of lobbying and capacity building and empowering tomorrow's human rights advocates with knowledge and skills. For nearly 80 years, what started with the Nuremberg trials was subsequently followed by many more accountability mechanisms designed to hold perpetrators accountable for committing war crimes, crimes against humanity, genocide, and the crime of aggression. One of these mechanisms is the Rome Statute for the International Criminal Court, which is the treaty that established the International Criminal Court, the ICC. It was adopted at a diplomatic conference in Rome in July 1998, and it entered into force 4 years later. As of February 2024, 124 states are party to the statute. On October 7, 2023, Hamas terrorists committed horrific crimes, including torture, sexual abuse, and murder against Israeli citizens, murdering 1,600 people and kidnapping 255 hostages, 115 of which are still held captive in Gaza. Israel, in response, waged a war in Gaza that has resulted in a critical humanitarian crisis, destruction, and the loss of thousands of more lives. On the 20th of May 2024, the ICC Prosecutor, Karim Khan KC, asked the International Criminal Court to issue arrest warrants for Hamas leaders Yahya Sinwar, Mohammed Diab Ibrahim al-Masri, and Ismail Haniyeh, and Israeli Prime Minister Benjamin Netanyahu and Defense Minister Yoav Gallant. There are several legal questions and implications arising from this move. Is it within the jurisdiction of the court? What about the court's independence and impartiality and the principle of complementarity? To help answer these questions and many more, I'm delighted to have with us today two renowned international law experts, Professor Noam Lubell and Dr. Maria Varaki. Noam is a professor in international law of armed conflict at Essex University and was previously the head of the law school. He has taught the law of armed conflict and human rights law at several institutions in the UK, Ireland, Switzerland, and the US, and also worked for human rights NGOs. Noam held the Swiss chair of the International Humanitarian Law at the Geneva Academy, is a research associate of the Hebrew University's Cybersecurity Research Center, and was the rapporteur of the International Law Association's Committee on the Use of Force. He recently co-authored the guidelines on investigating violations of international humanitarian law in collaboration with the Geneva Academy and the International Crescent of the Red Cross. Noam is also a member of the René Cassin Advisory Council. Dr. Maria Varaki is a lecturer in international law at the War Studies Department at King's College London. Before moving to London, she held research positions in the Erik Karsten Institute of International Law and Human Rights in Helsinki and the Law Faculty of Hebrew University in Jerusalem. Currently, she's a research associate in 3 generations of digital human rights at the Hebrew University Faculty of Law. Noam and Maria will speak for about 20 minutes each, after which we will open up the conversation for questions from the audience using the Q&A function. And finally, just to let everyone know, this event is being recorded. So I'm delighted now to invite Maria to be our first speaker for tonight.
Thank you very much, Mia. Thank you very much for this kind invitation to share a joint lecture seminar together with Noam, who I know many, many years. Well, although the topic is not the most, definitely is not a pleasant one, I'm here. I know that our audience is a mixed audience. So what I'm going to do within the next 10 minutes is to introduce our audience to the International Criminal Court and clarify as much as possible some of the concepts and issues you already touched upon in the introduction. So let's start with the International Criminal Court. As Mia mentioned before, the International Criminal Court is not the ICJ, it's not the International Court of Justice. And I'm saying that because within this particular conflict between Israel and Hamas, we have many, many legal proceedings, not only before the International Criminal Court, but also before the International Court of Justice. The International Criminal Court, which is a permanent international criminal tribunal based in The Hague, it prosecutes individuals. That's why today I'm going, together with Noam, we're going to explain the request for arrest warrants against particular individuals within the context of the Israel-Hamas conflict. So as I said before, the International Criminal Court is the first permanent institution, and it reflects the traditional character of international law, which is very much based on state consent. Only states which have accepted the jurisdiction, which are members, which have accepted the Rome Statute, as we say, the founding document of the International Criminal Court, they are bound by the jurisdiction of the International Criminal Court. I would like to clarify one more issue here before I proceed with the second theme, which is about the jurisdiction and admissibility. As I told you before, the International Criminal Court adjudicates the core crimes, as we say today in international law, which is the crime of genocide, war crimes, crimes against humanity, and also the crime of aggression. And it prosecutes and tries individuals. It's not about state accountability, it's about individual criminal accountability. This is very, very important. Now, having said that, the court has a very important feature, and this is what we describe when we talk about complementarity. What is that about? That the court does not have exclusive jurisdiction, but the jurisdiction, meaning the power of the court, is complementary to national jurisdiction. And this is a very important characteristic of the International Criminal Court, and this is an issue that I would like to talk a little bit more to explain to you some issues that have arisen and have triggered some controversy. Now, how does the International Criminal Court operate in the particular conflict? As I told you before, the court has jurisdiction, meaning it has the power to investigate alleged crimes that have been committed in a particular situation only on the territory of a state party or upon nationals of a state party. Now, in the particular conflict between Israel and Hamas, I'm sure you know, or if you don't know, Israel is not a state party to the Rome Statute, to the founding document of the International Criminal Court. However, Palestine since 2015 has acceded to the jurisdiction of the court. Initially, it launched, as we say, declaration. I don't want to confuse you, but although there was a massive controversy whether Palestine is a state and to what extent the International Criminal Court has jurisdiction upon Palestine's accession to the Rome Statute. In 2021, one of the appeal chambers of the International Criminal Court decided that for the purposes of the Rome Statute, Palestine is considered to be a state, and for that reason, the International Criminal Court has territorial jurisdiction on Gaza, on East Jerusalem, and on the West Bank. This is a very important characteristic, and it's a very important issue, as I'm going to explain in a while. But for those of you who are not familiar with the International Court, and it sounds, as I say, a bit oxymoron and antithetical to what I said before, that Israel is not a state party to the Rome Statute, based on Palestine's acceptance of the jurisdiction of the court and the subsequent judicial determination by the appeal chamber of the court has concluded that it has jurisdiction on the territory, as I said, of Gaza, West Bank, and East Jerusalem. And in this sense, all alleged crimes that might have been committed on these territories, they are under the investigation, the jurisdiction of the court. Now, before the prosecutor submits a request authorization for arrest warrants, it has to pass another test. So first I told you about the jurisdiction, which means the power of the court and the office of the prosecutor generally to investigate alleged crimes that have been committed on the territory or by nationals of a state party. The second test, because the Rome Statute has different filters, is what we call in international criminal law admissibility. And that means that a particular situation and afterwards case is admissible under the Rome Statute. Now, admissibility has one feature, and that is what we call complementarity. What does that mean? That the International Criminal Court that a particular situation is inadmissible before the International Criminal Court if the relevant state, as we say, investigates or prosecutes alleged defendant about situation and cases that the court itself started to investigate. So the court intervenes only if the national authorities are unable, as the Rome Statute says, or unwilling to investigate or prosecute someone who allegedly has committed war crimes. This is a thorny issue in the particular situation, I would say in the particular case with the arrest warrants against Israeli leaders, and I'm going to explain a little bit more now that I'm going to proceed with the arrest warrants. Now, when it comes to the arrest warrants on 20th of May, as Mia said, we heard that the prosecutor of the International Criminal Court requested an authorization by the pretrial chamber to approve arrest warrants against Hamas leaders, but also arrest warrants for war crimes and crimes against humanity against the Israeli Prime Minister and the Israeli Minister of Defense. Now, that doesn't mean that the court has issued the arrest warrants. There are legal proceedings. That means that the prosecutor himself submits a request for authorization for arrest warrants, and a pretrial chamber and chamber of 3 judges is going to examine to what extent the particular defendant falls within the jurisdiction, or as we say under Article 53 and 58 of the Rome Statute, there are reasonable grounds to believe that the particular defendant, in that case we call it case, falls within the jurisdiction of the Rome Statute, and all the tests of admissibility, such as complementarity and gravity, have been fulfilled. Now, this is the final point I'm going to make here before I give the floor to Noam, who is going to talk more about the content of the arrest warrants. But I would like to say that the particular legal initiative has triggered a debate among legal scholars and different states. particular states have raised concerns, and actually they have resisted this initiative by the prosecutor of the International Criminal Court for, I would say, ethical or moral issues. But here we talk more about the legal issues. At the end, we're going to talk a little bit more about the policy issues. But when it comes to the legal issues, several states, they say, and I can bring here the example of UK. The US is a different case because from the beginning, the US has not accepted the jurisdiction, is not a party to the Rome Statute, and has a very strong position and clear position that the International Criminal Court does not have jurisdiction on the particular situation in the occupied Palestinian territories. But when it comes, and there is a series of reasons for that. One of them is that based on the Oslo Accords, that according to the Oslo Accords, the Palestinians do not have jurisdiction upon Israeli citizens. Actually, this is one of the claims that allegedly the British government the British state was going to make before the International Criminal Court. But on 26th of July, the current government in UK decided not to proceed with this opportunity to challenge the jurisdiction before the International Criminal Court. However, there are other states that they are going to make this claim that the court does not have jurisdiction with regard to the Israeli citizens. And there is a second issue which is very important about complementarity. There is a debate to what extent the Office of the Prosecutor actually proceeded way too fast with regard to complementarity without giving a proper notice to the Israeli authorities that his office was going to submit an authorization for arrest warrants. There is a counter argument with this regard that Israel and the Israeli authorities, they were aware of these particular initiatives in the sense that the Office of the Prosecutor already investigated the situation. It's called the situation in Palestine, and that they were aware that he had given some warnings. However, there is the other opinion that the particular application of complementarity by the Office of the Prosecutor was not an ideal one. And this is something that is going to be further challenged. I would like to stop here with this very brief introduction to the International Criminal Court. As I said, it's the first permanent court. It deals with individuals. It deals with individual criminal accountability. It's the first time that the court, it's not the first time, but we are going to discuss a little bit more during the other round. But I would like to stop here and give the floor to Noam to continue with the international humanitarian law and the actual content of the arrest warrants. Thank you.
Great. Thank you very much for that, Maria, and thanks also, Mia, earlier for the introduction, and good evening to everyone who's following this, including, I think, some people we all know. So hello to everyone. Before I get into the substance of the claims being made and the accusations in the arrest warrants, I just want to also note that, as I'm sure many of you know, there was another development legally regarding this conflict, although not about the specific war in Gaza right now, and that was the advisory opinion issued by the other court, the International Court of Justice, just around a week ago. So if we have time, and hopefully we will, we can come back to that in the Q&A. So just to say that we can answer some questions on that within the time, if possible. But right now I'm going to focus on the subject that was advertised for this event, and that's the arrest warrants. And I want to talk about the substance here in terms of what's going on. So let's talk about what they actually are, what the people are being accused of, what this means, and also some of the legal and factual questions that surround all of this. So the accusations, first of all, starting with the accusations against Netanyahu and Gallant, really all revolve around the issue of starvation and denial of sustenance. All right, so there's the accusation of committing the war crime of starvation of civilians as a method of warfare. Right. Then there are other elements here, including causing great suffering, willful killing, extermination and or murder, directing attacks against the civilian population, persecution. But all of this is linked back to the alleged policy of starvation. Right. So this really is the central theme of the accusation. And the accusation is that this occurred through the imposition of a total siege over Gaza, closing the border crossing points, cutting off water pipelines, cutting off or hindering electricity supplies, attacks on civilians, including on people queuing for food, obstructing aid delivery, attacks on aid workers. And all of this together paints the picture in the accusations of a policy, essentially, of starvation as a method of warfare. Now, I suppose the first thing to maybe explain is why this focus on starvation, because there's been a lot going on in this conflict. There have been plenty of criticisms against Israel for all sorts of actions, and of course against Hamas. But the prosecutor chose to focus on starvation. And there are a number of reasons for this. The first is the ICC tends to focus on prosecutions of those in leadership positions. So that means it needs to find enough of a link between them and the alleged crimes to the extent that the leaders are individually criminally responsible. And that's not always easy to do with a lot of the violations that have been alleged as part of this conflict. And we can come back to that if we have time in terms of sort of other things that might have been alleged. But with starvation, the prosecutor will have believed that the connection is easier to prove because of statements by politicians seemingly indicating denial of food and sustenance as a policy. Right. In addition, the scale and the gravity of the situation was something that was reported by international agencies as extraordinary, devastating, affecting most of the population in Gaza, and particularly concerning for children. It was also something that the prosecutor and others had repeatedly asked Israel to address. And from their perspective, it wasn't being investigated, unlike some other things that Israel said it's investigating. The prosecutor would have taken the view that at least Netanyahu and Gallant weren't being investigated in Israel for the policy of starvation. So from the prosecutor's perspective, this wasn't ruled out by complementarity, right? Because there weren't proceedings in Israel. Now, Maria has already explained that there are some questions around this and whether that was the correct approach. But again, this is just in terms of the background, why the focus on starvation. Now, the crime of starvation includes a few elements, but the key ones for our purposes are that the perpetrator deprived civilians of objects indispensable to their survival, and that the perpetrator intended to starve the civilians as a method of warfare. So let's look at the strengths and weaknesses and challenges surrounding this case. The strengths on which the case relies are two fundamental and connected points. And they are, first of all, many statements, including by Netanyahu and Gallant, about not allowing food and aid into Gaza. Right? Now, that was coupled with a second point of numerous reports by international agencies about starvation and lack of basic needs, and reports on impediments to delivering aid and even military attacks on aid and humanitarian workers. And these two things combined, from the prosecutor's office perspective, to demonstrate that there is this policy that is indeed being carried out. It also won't have helped the Israeli government that in recent months, Israeli civilians with support from far-right politicians were impeding humanitarian aid delivery into Gaza, and the police were clearly not doing enough to stop them. And this will also have bolstered the view that Israel wasn't doing enough on the aid front. So for some people, this, and clearly for the prosecutor, this all means that the case is relatively straightforward in that sense, at least in terms of what's needed to start out with the arrest warrants. That doesn't mean it's straightforward in terms of the trial, but at this stage, there are lower grounds, lower threshold. Now, at the same time, there are also a lot of debates and challenges that complicate the matter, and looking at it from other perspectives make it not so simple. And some of these surround the issues that Maria mentioned on admissibility of the case in the first place, right? Palestine as a state, the issues of complementarity, whether it would have been more appropriate to wait and see whether Israel conducts investigations and is this too early, and various other issues around admissibility. But I want to focus on the challenges of the case from the substantive side of things. So starting with the statements, one of the difficulties is answering the question of which statements count. Right, so lots of politicians spoke, but many of them were not the ones who set the policy. Now, that doesn't mean that what they said was okay, but it does mean that not all statements necessarily are the same, provide the same level of proof of a government policy. Now, given that these are accusations specifically against Netanyahu and Gallant, the key will be focusing on their statements rather than those of other government members, especially if those other government members were not part of the war cabinet. So that's one thing in terms of how we look at the statements. Another matter that's going to need to be addressed is whether these statements lined up with a particular policy that was implemented in practice. So the critics claim that the practice did indeed demonstrate deliberate impediment of aid. And then Israel, on the other hand, will claim that it's been doing everything it can to allow aid in very difficult circumstances. Right? And again, determining this is a factual question that will need to be done. There's also an important point that's been picked up by international legal experts, but isn't always clear to others. And it's going to sound a little technical, but I'm going to get into it because it's really important here. And this is that in some cases of the statements, including those by Netanyahu and Gallant, it's claimed that they weren't necessarily referring to blocking food or aid delivered by third parties, but rather that they were referring to stopping the supply of water and electricity previously provided by Israel itself to Gaza. So, for example, on October 18th, one of the statements that Netanyahu made is that we will not allow humanitarian assistance in the form of food and medicines from our territory to the Gaza Strip. Now, why does this matter? Because this relates to a key legal debate that could have real implications for this case. And that's whether Gaza is considered occupied territory or not, in particular at the start of this round of the conflict, of this war. And that's because when it's an occupation, the occupying power has positive obligations to ensure food, medicine, and other essential supplies. So in other words, not only to allow humanitarian organizations access, but to ensure provision of these itself, if that's necessary. And this question of Gaza status is, it's a complicated one that's been ongoing since the withdrawal of troops almost 20 years ago. And there are two opposing views, simply and briefly. One view is that after 2005, Israel was no longer an occupying power in Gaza, given that it had no troops on the ground and didn't exercise the kind of control and authority that you usually associate with the law of occupation. The other view is that even without troops, Israel retained certain control and functions that meant it still held the obligations of an occupying power. Now, that was the debate until this war began. Of course, even if Israel wasn't an occupying power before the war, one could argue that at certain points during the war, it began exercising the kind of control over parts of Gaza, especially in the north, which might meet the criteria for occupation and therefore do create these extra obligations to ensure itself all of the basic supplies, right? Now, how you view these issues is more than just a technical legal question, and it can affect actually whether some of the charges hold. Now, that's because well, for one reason, that's because the crime of starvation that was alleged is one that applies in international armed conflicts, as opposed to non-international armed conflicts. We have in international two types of armed conflicts, right? International between states and non-international between armed groups, or between a state and an armed group. And there's some debate whether the Gaza war is an international armed conflict or a non-international armed conflict or a combination of the two. Now, if it's determined that Israel was an occupying power in Gaza even before this started, then this brings the rules of international armed conflict more clearly into play. And it would provide the basis for the crime of starvation as it applies in international armed conflict, and also would mean that Israel has a higher level of positive obligations to ensure food and other sustenance, right? But if, on the other hand, you take the position that Israel wasn't an occupying power before this war broke out, and might have only become one in the context of establishing control over some parts of Gaza during the war, then the precise dates matter, because the statements used for the charges might be assessed in light of different types of legal obligations, right? Whether it's to actually provide the food and water, or whether it's to allow others to provide. Now, I should note that in this regard, the International Court of Justice, the other court, and I mentioned their recent advisory opinion, they took the view that Israel retained certain obligations after the 2005 troop withdrawal. So this could bolster the ICC prosecutor's position on the matter, but it is a question of debate, and it's important to understand that these technical legal questions of how you classify a situation could actually affect whether certain charges hold or not. Another issue as far as the substance and establishing the crime itself is the discussion and disagreement that we can expect around the element of intent. So the easiest way to fulfill this and to show this is if you could demonstrate, right, if the prosecutor would be able to demonstrate that the act was a deliberate deprivation of sustenance from the civilian population. Right? That would be the easier course if that could be demonstrated. The other course of action, and one over which there's a bit more disagreement of how this actually works and what it means, is in circumstances in which denying sustenance from the civilians is not the primary aim, but it is nevertheless a clearly foreseeable consequence, right? So again, how statements by Israeli officials are viewed is going to play a role in the assessment of intent. Now, the facts of the case are going to matter, as is always true in legal proceedings, right? And some of the facts, again, that might complicate this are that the initial closure of the crossings was in the context of the October 7th attacks. Right, so at that time, at least, could have been seen as a security measure, right? And it was reported at the time, and I don't have all the facts. So I'm not here saying what is correct or not, but just in terms of arguments that may come up. It was reported at the time also that some of the electricity and water lines into Gaza were actually cut by Hamas during the attacks. So again, that's going to be something that they're going to have to look at. There's also the point that some of the actions were conducted as part of sieges of specific areas, such as Gaza City, right? That's different to a siege on the whole of the Gaza Strip, right? And there were different levels of control over what goes in and what goes out, if you look at the Gaza Strip as a whole and various areas inside it during the war. Now, there's a legal debate around the rules on sieges in modern warfare, especially whether it's allowed to deny sustenance to civilians as a way to force them to evacuate an area from which the enemy is fighting. And this is tied into questions of warnings and providing safe passage, which have also been the subject of a lot of scrutiny and criticism of Israeli actions throughout this war. Now, Israel might argue that applying this kind of pressure isn't starvation if the civilians are able to leave these areas and have their needs met outside the designated fighting area. Now, again, whether that was actually the case and whether they were able to do that is a factual question and has itself been the subject of a lot of critique. There's also questions that have come up around the role of Hamas in preventing supplies from reaching the population, especially by diverting aid for its own use. And this, again, is likely to be part of an argument that Israel, or in this case, any defense of Netanyahu and Gallant, would make in relation to the ways it tried to control and implement aid delivery. It's important to note that there was an expert panel that advised the prosecutor on this, and they clearly, they looked at this question, and their view was that while military considerations can come into play, that's only up to a point if they end up having a disproportionate effect on the civilians. Right, so I mentioned all of the above simply to point out that there are disagreements over the law and the facts that are likely to be raised as this case proceeds. Now, there were also, of course, in the arrest warrant applications, there were also accusations made against the Hamas leaders. These included extermination as a crime against humanity, murder as a crime against humanity, taking hostages, rape and other acts of sexual violence, torture, other inhumane acts. And the focus of these accusations was on the October 7th attacks and the continued holding of hostages. Now, I'm not going to spend as much time on these, also because we want to sort of move to the Q&A, but also because the law and the facts on these particular accusations are relatively straightforward. So overall, the October 7th attacks were widely reported and the basic facts were acknowledged, including on the basis of videos taken by perpetrators. So there's less of a challenge demonstrating the grounds that are needed at this level, reasonable grounds to believe crimes have been committed, right? That's what you need to demonstrate at the arrest warrant stage. And these specific crimes are also subject to less debate and controversy. Again, especially when their manifestation has been recorded so clearly. The only argument I've heard some people try and make here is that the hostages are prisoners, not hostages, and that you can take prisoners in war, and also that many of them are soldiers. Right? Now, the problem with both of those arguments is, first, the rule on hostage taking is actually not about the status of the person, whether they're civilians or soldiers, or combatants, as we say in legal terms, but it's more about how they're being used in detention, and it can actually apply to the taking of soldiers as well. So, if they are being held in a manner that meets the definition of hostage taking, and in this case it clearly does. And second, a large proportion of the hostages are clearly civilian, and there could have been no mistake of their status if you think about the nature and locations of their abductions. Right. The other important point, maybe just to note about the charges against the Hamas leaders, is that given the concern over sexual violence and the initial very poor and disappointing response by the international community, it's notable that the prosecutor did find reasonable grounds to believe that these acts have been committed, and that is in the accusations. So there are also all sorts of other violations that might have been raised but weren't. The prosecutor has left open the possibility of further charges being brought forward in the future. Perhaps I'm going to end with my bit here because of time, but maybe in the Q&A we can come back to that, and I can explain a little bit why I think at this stage other charges weren't leveled at either side, but what might come later. So I'll hand back just briefly to Maria for a little bit on the repercussions and the politics around all of this, and then we'll open up for Q&A. Maria.
Yes, thank you very much, Noam. Well, while you were talking, I was thinking also about this issue of expressiveness. One of the issues why each prosecutor chooses a particular crime in international criminal law, it's also about the expressive value of particular crimes, but definitely all the issues you raised are very, very important. And as you say, there is an open investigation, and the prosecutor himself has claimed that further charges might be added. And you mentioned already the advisory opinion, which is very, very interesting from a couple of days ago regarding the occupation. I was thinking again about the repercussions with regard to the International Criminal Court. Now, having said that, I would like a little bit to touch upon issues of politics, of the broader picture, as we say, because we have heard every prosecutor to say, I just apply the Rome Statute. This is not a political instrument. It's just a legal institution. But this is far from true. The International Criminal Court is an institution, but it operates within politics, and law and politics come together. So I would like to highlight a couple of points with regard to the International Criminal Court. It has more than 20 years now in operation, 22 years actually, since 1st July 2002, and the court has been the subject of massive critique regarding legitimacy, credibility, where it focuses, whether it was way too pro-African, to what extent there were no Western leaders before the International Criminal Court. And there was pressure on every prosecutor to change the image of the court, and also to respond to this critique. And after the arrest warrants against President Putin, I would say, which was another milestone with regard about a head of one of the 5 permanent members of the Security Council. Now the arrest warrants against the 2 Israeli leaders are also extremely important, because this is the very first time that we have a Western power and Western leaders before the International Criminal Court. So I'm not saying here that this was the reason. I'm suggesting here that we shouldn't underestimate the broader context and the political pressures upon the prosecutors from different stakeholders. That they need to do something, because the court had a massive issue, a problem of legitimacy, of image, of credibility, of effectiveness, of everything. Now, when it comes to the position of several states, I would say again that there was a problem of double standards. We have this massive discussion about double standards in international law, like international law is something objective and there are no double standards. So there were accusations and debates why states such as the US did not react to the arrest warrants against Putin, for example, for the invasion of Ukraine, and they reacted so badly about Israel. So there were positions between different states. We saw that some states had very strong statements, some European states as well, that they felt that the particular move by the prosecutor of the International Criminal Court did not contribute into the solution of this conflict. To the opposite, they say they made a claim that actually this move might have derailed any possible discussion about the ceasefire, about the release of hostages, about the improvement of the dire humanitarian situation on the ground. And on the other hand, this particular move was considered by other sides to be a proof that law speaks to power, and that finally the International Criminal Court saves and stands on its own feet. Now, when it comes to repercussions, maybe here Noam would like to fill in as well. And there was a question about who is going to decide about guilt or innocence. International criminal justice is a very, very slow process first. And something we have to understand is that the International Criminal Court does not have police, does not have an army. It cannot go to Israel or anywhere and arrest those people. This is one of the weaknesses, as we say, of the international legal system. It depends on the cooperation of states and the cooperation of other parties, to what extent, in case we have arrest warrants, although I believe that this process is going to last for a while due to the objections, to the legal objections that they have been raised. But in case we have an arrest warrants, the issue is, will they be executed? And what does that mean? That means, for example, that Netanyahu, Gallant, I'm not talking about Hamas because this is a different story over there, to what extent they fly and where they fly. I'm talking again about the Israeli leaders. It will be very difficult for them to fly to state parties of the International Criminal Court, because states have an obligation to cooperate with the court and to execute the arrest warrants in case those arrest warrants are issued. And most likely they will be issued at some states later, but they will be issued, which means, of course, that those leaders are limited. We shouldn't underestimate the damage to the credibility, to the image of the leadership of a state. This is also extremely important. And also the pressure upon other states, not only to respect the international criminal, the Rome Statute and the judgments, the decision of the International Criminal Court, but also the pressure states and leaders will have and already have. We have seen that in different states with regard to other relations such as trade, okay, and arms. This is very, very important. There is lots of pressure, and we have seen in different countries, in Holland and other countries. Today, I was reading about UK again, that there is pressure, together with the advisory opinion by the ICJ, that states have to screen and to be more careful when it comes to their relation with Israel and the particular leaders. So even though those arrest warrants will not be like it will be quite difficult. I would say, I'm not going to say impossible because anything is possible, but I don't foresee in the near future the Israeli leaders to be before the International Criminal Court for the issues I raised here. Definitely their life is going to become more difficult, and not only their life, but also the relations of the state itself. Maybe Noam, you would like to add something in this regard? Thank you again.
So maybe I'll turn some of the questions that are starting to come in. So there's a question about the challenge of for a fighting force to be expected to feed its enemies if the enemy is reported to be benefiting from the supplies. This, in the laws of armed conflict, this is a long-standing dilemma. Goes back decades, over a century, and more in terms of how one deals with sieges and so on. And if you actually look at the first additional protocol to the Geneva Conventions and the article that deals with this matter, it is one of the most convoluted and difficult to read articles in all of international humanitarian law. It's got a number of paragraphs that seem to contradict each other, and it's twisting and turning and trying to figure out what to do precisely because of some of this. But I would say that the understanding in recent decades has coalesced around the fact that at the end of the day, you cannot be implementing a policy that knowingly ends up starving civilians. All right. One way or another, there's different ways that you end up with that conclusion. Part of this links to what I mentioned earlier, the discussion around sieges. And so, okay, so what you can do is, and again, this is also debatable, but some would argue what you can do is you can lay siege to a certain area, and then you allow all the civilians to leave and ensure they are fed and cared for elsewhere while you trap the fighters inside, right? So that's one answer that some would take. But what I think most by now would accept is you can't end up in a situation where civilians are starving to death, and so again, it's an extremely technical, complicated legal question, which brings lots of laws into play. But I'd say that's sort of the bottom line of where most would end up nowadays. There was a question about Palestinians being held by Israel. I think the question, certainly the treatment of Palestinian detainees, may be something that, if there are further charges that could come up, that's because there have been lots of reports of ill treatment of Palestinians in Israeli custody since the start of the war. That being said, again, remember what we spoke about in terms of complementarity. And so if Israel shows that it is investigating these allegations itself, and just today there were arrests made in Israel in one of the detention centers of Israeli soldiers for abuse of a detainee. Now, again, whether that's enough or not is a different question, but just to say that this is the type of example where you start having discussion of complementarity and whether it would be right for the ICC to intervene on a matter if the state says, well, we are looking into this ourselves. There are other violations that might be alleged, and look, we don't know what these would be, but one of the things that I would assume is being considered relates to the conduct of hostilities, how attacks are actually being carried out. And here, these are basic rules that many of you, even if you're not experts, will have heard about in terms of sort of distinction and proportionality. So the idea that you are only allowed to direct your attacks against military or military objects, and you must never intentionally attack civilians. And if you're attacking something military that might then cause collateral harm to civilians or civilian objects, it has to be proportionate, right? Now, again, without getting into the details of all of those are sort of very basic, fundamental principles with very specific rules. And a lot of the criticism in this conflict has surrounded those rules, but one of the reasons that charges would not have been brought at this stage is that it's really difficult to prove violations without the facts, right? So for anything to do with the conduct of hostilities, you need to know, what did the commanders know? What were they actually directing their attack at? What did they expect to gain? What could they have expected in terms of the collateral harm to civilians? What were the precise circumstances? What options were available at the time? And this gets even more complicated in urban warfare when the enemy is embedded in civilian areas, where your target is a flat in a building that is, other flats are used by civilians, but one flat is used by the military, or cellars, underbuildings, tunnels, right? When hospitals or schools are alleged to have been used by the enemy, it makes all of these questions of distinction and proportionality a lot more complicated. And so determining and having enough to make an accusation right now for an arrest warrant would be particularly difficult. Okay? It's the kind of thing that you usually only find out later on with more detailed investigations. You also need to keep in mind that the International Criminal Court is generally focused on the acts of, as I mentioned, of leaders. And so you need to separate between violations and war crimes by troops in the field, including commanders in the field, as opposed to the charges that might be brought against the leadership. So even if you have videos and testimonies that point to unlawful acts by soldiers, and some of these are investigated by the IDF, again, whether enough and whether being properly investigated is a different question. But unless you can prove that that's part of a policy from above, or that is being tolerated and allowed to continue, which is perhaps the more likely route, then it's difficult, at least at this stage, to charge the leaders with responsibility for these crimes. Right now, as I said, you could do that on the basis of they know that all of this is happening, even if they didn't order it and they're not doing enough to stop it. But it does get a bit more complicated. We could also see more charges brought against Hamas leaders in relation to conduct of hostilities, and most obviously rockets fired into civilian areas of Israel. Okay, so similar around the conduct of hostilities. So that's another area where we might see more. So there's lots of things that could still happen, but there's a reason that right now the focus was on starvation. Maria, any questions you want to?
Yes, and I think you have a final question about Egypt. If you want, I can respond for.
Oh, sure. Yeah, I can see that one there. So, obligation to allow food and water into Gaza before 7 October, noting there was a border with Egypt. So a lot of this comes back to whether Israel was an occupying power or not before October 7th, because that affects the level of obligations, right? There's also questions around this that relate to the relationship between Israel and Egypt, and if they are jointly implementing a policy that they agree on in terms of what goes through the various crossings or not, which at least some would say that that's been the case, right? And then you can have questions also of joint responsibilities and so on that get a lot more complicated. Now, there's a difference between an obligation to allow food and water by others and providing it yourself. And even without the laws of occupation, one would expect allowing food and water to come in by others. The bigger question with the laws of occupation is whether you have to ensure it yourself as well.
I think I can not combine. There is one from Ruby and one from Anthony. Anthony, there is a big discussion and debate about head of state immunity before international court. We know already from the arrest warrant before the ICJ. We had a case regarding Sudan when South Africa asked, when Jordan asked an advice. Well, to put it mildly, I would say the predominant position, although it's still very controversial, is that there is no head of state immunity before an international court, an international criminal court. So, in this regard, if if Netanyahu and Gallant, I'm talking about these two defendants. Anyway, these people against the arrest warrant, if they travel to a state party, there is an obligation to execute the arrest warrant. This is an issue that has been for al-Bashir, that it was raised before the International Criminal Court with many interventions by legal scholars and states. Debatable. but the predominant position is this one, that there is no head of state immunity before an international court. It's different when it comes to domestic courts. I'm not going there, but I'm talking about the international court. Now, Ruvik, the prosecutor did something unprecedented this time. Noam mentioned he had a panel of experts. So he asked advice outside the court, apart from his legal advisors and apart from the usual people around him. He asked other experts to help him with a particular investigation. That gave more. It can be read different ways. I don't want to go why he did that. And why he decided to do that, but that shows a little bit a different approach and how he wanted to build up his case. My feeling is that the arrest warrants will be issued. That's my feeling. I believe there will be a delay due to those challenges. Some of those challenges will be raised by serious scholars. There are serious issues. There are counter arguments, in particular with regard to complementarity, the same conduct, same person, but also the issue of time of the notice. There is a problem about the notice, whether the notice was given a long time ago, because you need 1 month notice. And there are issues about jurisdiction that it seems that the court doesn't deal with jurisdiction, like it took it for granted that there is jurisdiction. I would be surprised, but that's my feeling. I would be surprised if we have a massive change of mind. I think there will be a delay, but again, I would be surprised for a different result. That's my take, and maybe I'm wrong. Thank you.
Mia, do we have, I know we're coming to 8 o'clock, but if we have a few minutes to go over, maybe I could say something about the ICJ advisory opinion, in case some of our audience, who of course are free to leave at 8 or now, but you can say a few words about that. It might interest the audience.
Yes. So I would urge whoever is still in this conversation to stay past 8 o'clock, but certainly no.
Okay. So in that case, just a few words on a completely different legal proceeding, but it's very relevant to generally the Israeli-Palestinian conflict, and in my view is potentially more likely to end up with real life effect, and that's despite it not even being a case. What do I mean by that? So this was the International Court of Justice. The other court was asked by the UN General Assembly to provide an advisory opinion. So it's not a contentious case between two sides, but the UN asks its own court to provide an advisory opinion. And this was an advisory opinion essentially on the legality of the ongoing occupation as a whole. Right. The wording of it was a little longer than that, and the wording itself was particularly problematic. But that was the question before the court. And the court gave its opinion just a few days ago, saying that, and this was a large majority for all the points, for all of its findings, and quite striking in that sense, because it's not always the case, right? And the court's opinion was that Israel's continued presence in the occupied Palestinian territory is unlawful, that Israel is under an obligation to bring to an end this unlawful presence as rapidly as possible. Now, the language is important, as rapidly as possible, right? That's not the same as saying immediate, but it also doesn't mean take your time. The court was of the opinion that Israel was under an obligation to cease immediately all new settlement activities and to evacuate all settlers from occupied Palestinian territory, to make reparation, but also that other states are under an obligation not to recognize as legal the situation right now, and not to render aid or assistance in maintaining that situation. Right now, this really is, in terms of the effect, this is the one that may bring all sorts of proceedings across the world in different countries in domestic systems, politically and legally, to try and stop any interaction essentially with Israel, economic, military, trade, academic, and so on, if it can be shown that this interaction provides support to the continuation of the occupation. Right? So this, I would argue, could have certainly short-term and long-term more effect actually than the arrest warrants, because the arrest warrants may or may not be issued. They will take a long time. They deal with two particular people, and if those two people don't get on an airplane, it might not change much. I mean, it will politically in all sorts of ways, but this is the one that actually, the advisory opinion, this is the one that could affect things like trade and economic agreements, military cooperation, and so on. So it's important to understand that this just happened. It was about the occupation more generally. It was not about the current war. In fact, a lot of it seems to be more relevant to the West Bank than to Gaza. And some of the judges' individual opinions actually focus on, saying this is really, primarily more relevant to the West Bank. There were criticisms of this, including by some of the judges who were concerned that the court didn't give enough space to talk about Israeli security concerns. But at the same time, most of these judges that expressed this concern with how the court worded it still ended up agreeing with the bottom line of the court. Right, so and some notable and well-respected judges, including the American judge Sarah Cleveland, the German judge, and others, they had their criticisms, but still ended up agreeing with the majority on these points. The opinion also spoke of Israel violating an article of the Convention on the Elimination of Racial Discrimination, and they spoke of an article which covers both the prohibition of racial segregation and also apartheid. So it's one article that mentions both, right? But they left it open, which one they meant, or both or not. They just said this article was violated. So some people, and including if you look at the opinions of the judges, some of the judges said, oh, look, this means that Israel is in violation of the apartheid prohibition. And other judges said, no, this does not mean apartheid, but at the same time, it's still a violation of this article, which would mean if it's not apartheid, there's only two things in there, it's apartheid and racial segregation, right? The bottom line is, and the striking part is the declaration that Israel's presence in the occupied Palestinian territories is unlawful. And it's striking because there's a difference between saying some of the policies of the occupation are unlawful and between saying the presence of Israel per se is itself unlawful. So they went quite far in that sense, and maybe further than some might have expected. Now, the bottom line I'd say here is that attaching illegality to Israel's policies, that's no big surprise, right? The settlements are at the heart of this. There was never any good legal argument to support the creation and expansion of Israeli settlements. Right? The majority of international lawyers, including in Israel, have always viewed the settlement activity as unlawful. There's a reason the High Court of Justice in Israel never dealt with the settlement policy as a whole. It's because they wouldn't have been able to do anything other than say it's unlawful, because the law is relatively clear on this. And it created a legally untenable situation with blatant cases of differential treatment for two sets of people in the same area on everything from housing to allocation of drinking water. Right. Now, one of the arguments over the years for it being sort of a regular occupation and not something unlawful was that the military had overall authority over much of the activities. But the current government then went and transferred some of the authority and control into the hands of one of the far-right political parties. And this is a major departure from the laws of occupation. So together with other government policies, it made it really hard to claim that Israel views this as a temporary military occupation. Right? So for all of these reasons, I don't think it's a big surprise that we ended up where we are now. But this advisory opinion could have significant implications, and I think that's one that people should be aware of. Sorry, yeah.
Yeah, I'm just going to say, Noam, I think you just gave us a taster for the next session hosted by Renee Kassan. So watch this space. Noam and Maria, conscious of time, if there's a last comment or intervention either one of you would like to make, then make it now. So I just want to thank you both, Maria, joining us from Thessaloniki, where it's very, very hot, and Noam joining us from London, where it's very, very hot for a change. Thank you very much for a really informative hours worth of discussion. You took us through a whirlwind of 101 on international human rights law and humanitarian law. And I think there's going to be lots to reflect on. And to our audience, thank you for joining us. Please support our work, being the voice for the importance of human rights values and principles. And please join us on our next event, which is not on Israel-Gaza war, but actually on the forced labor of the Uyghur minority, and specifically within the solar panel industry. And that will be in mid-October, and we will send a link. So again, thank you very much, Maria. Thank you very much, Noam. And a good night to everyone.
Thank you very much. Thank you.
Thanks. Bye-bye.